The following presentation is part of Brinks, Hofer, Gilson, and Leon series on the America Invents Act.
Hi, my name is Ryan Marshall. I'm a shareholder at Brinks, Hofer, Gilson, and Leon. In my presentation today, I'm going to talk about prioritized examination, a fee-based path to completed patent examination within 1 year. In my presentation today, I'd like to review the background leading up to the prioritized examination procedure, as well as the various options that are available to expedite patent examination, the requirements for an application to qualify for a prioritized examination, and strategies and best practices for integrating prioritized examination with intellectual property rights and protection. So, in beginning the presentation, I'd like to first turn our attention to what happens with patent examination. Normally, when a patent application is filed, it's examined in the order in which it was filed with the Patent Office. In other words, its effective U.S. filing date. Patent applications undergoing examination at the USPTO on average do not receive a first action for about 2 years or 23 months. And final action on that application, an allowance or a final rejection, typically takes just under 3 years or 34 months. In some cases, the current pace of examination is acceptable, and other circumstances may justify faster examination. For example, a patentee can't enforce his or her patent rights until the patent is actually granted. So if there is an infringement taking place, one in which the patentee wants to stop, then it's necessary to get that patent to grant very quickly. And they may be handicapped. In other words, you won't be able to enforce your patent rights until the patent is granted. In addition, some licensing agreements require that the patent be granted before royalties or revenues are obtained by the patentee. Other circumstances which might justify a more speedy path to patent grant are the need to get competitive advantages arising from exclusion of that invention or technology from the marketplace and keeping it to the patentee, him or herself. And there are also fast-moving and changing technologies, such as in the electronics space, where the patent value is really during the first few years after its innovation, before it becomes outdated. So there are a lot of circumstances in which a patentee might want to accelerate or speed up the examination process. Now, there are options available already before prioritized examination, but I'd like to review what the options are. First, the Track 1 program or prioritized examination, which this presentation will focus, is available. Patent prosecution highway or Montani proceedings, which enable an applicant to get claims that are allowed in one country granted in other countries very quickly. There's also a special status that's given to applications where the inventor is older or of poor health, or where the inventions are materially the invention may materially enhance the environment or conserve energy resources or counter terrorism. There are also special technology-driven pilot programs the Patent Office has used, such as for green technologies, and that program ended recently in 2012. There are also accelerated examination proceedings in which a patent applicant can do a prior art search and then include a very detailed statement about why the claims of an invention are distinguishable based on the prior art search conducted by the applicant. Now, it's important to realize at this stage that accelerated examination and prioritized examination are two different proceedings and have very different requirements. So don't get them confused. Now, let's turn our attention to prioritized examination. That became available in September of 2011 after passage of the American Invents Act. And specifically, the rules that implemented prioritized examination enabled applicants to begin filing their applications with requests for prioritized examination by September 26th. And then in late December, applicants could also seek prioritized examination when filing requests for continuing examination. Prioritized examination gives an application enhanced special status through a shortened pendency period. And the USPTO has a goal, and it's just a goal, to reach final disposition within 12 months of the request for prioritized examination. If, however, the Patent and Trademark Office does not meet that goal, there will be no refund of the additional fees an applicant pays for prioritized examination. So the Patent Office wants to reach a final disposition of an application within 12 months. Now that final disposition can be triggered by a number of events. For example, a notice of allowance, which is what as a patentee you want to obtain. A final rejection or office action rejecting the claims. Those events by the Patent Office will conclude prioritized examination. But there are other things that the applicant might do that trigger the end of prioritized examination. For example, filing an RCE or request for continued examination, filing a notice of appeal, or abandoning the application. Those events will end prioritized examination. Also, if an applicant changes the claims in a way that the application no longer qualifies for prioritized examination in responding to an office action, that will also change the application and revert it back to normal examination. Now, not all applications are eligible for prioritized examination. Those applications that are eligible include utility and plan applications, continuation or divisional applications, and Section 111 bypass applications that arise from PCT or Patent Cooperation Treaty applications. Ineligible applications include design applications, re-exam and reissue applications, as well as Section 371 or PCT national stage cases. So before you undertake the effort to proceed with prioritized examination, make sure that you know what type of application you're filing and whether or not it's eligible. Prioritized examination is also only available for applications that are filed with the U.S. Patent and Trademark Office using their EFS web system. You can't paper file an application and then seek prioritized examination. When the application is filed, there are certain requirements that must be met for it to qualify. And I'm going to review those requirements now. They include having a fully executed oath or declaration by the inventors, a specification that's fully compliant with the rules, formal drawings if there are any drawings, and if there are sequence listings, large tables, or computer listings, those have to be electronically filed as well. In cases where a foreign priority claim is relied on, then that claim should be identified in the executed oath or declaration or identified on an application data sheet. Complete applications also require that an English translation of the priority document and a statement certifying the accuracy of that translation be included with the application. A domestic priority claim, such as one filed provisionally or non-provisionally in the U.S., must also be identified in the first paragraph of the specification or the application data sheet. And then the other particular requirement for prioritized examination is the payment of fees, including any excess claim and page fees at the time the application is filed. When drafting applications, there are specific provisions that modify what types of claims can be sought. Particularly, the application is limited to no more than 30 claims, and 4 independent claims. The rules also prevent you from including any multiple dependent claims. And we'll talk more about those requirements in a moment. The fees associated with normal examination of an application include the payment of a large entity $1,250 fee, or for small entities, roughly $530. Those fees change from time to time and are updated usually in October by the Patent Office as their fee schedule changes. Now, in addition to the normal examination fee that an applicant pays, if you want prioritized examination, you'll also have to pay a $4,800 fee for large entities or $2,400 for small entities. And that's a pretty significant fee, so it's something that should be contemplated and invested appropriately. In addition to those fees, you'll have to pay a $130 petition fee and a $300 publication fee. Ordinarily, the publication fee is also incurred during normal examination, but not until the case has been allowed. So that ultimately isn't an additional fee, but it's one that you have to advance at the beginning rather than at the end. Now, if a petition for prioritized examination is denied, the prioritized examination fees will be refunded except for the petition fee. So if you don't get it right the first time, you are out the $130 petition fee. Now, unlike the PTO's accelerated examination program that was implemented back in 2006, the prioritized examination process does not require the applicant to do a pre-examination search or provide any statements in a supporting document demonstrating the inventiveness of the claims over the prior art. And again, that is a distinction that you should keep in mind between accelerated examination and prioritized examination. Upon grant of the petition, an applicant can expect to receive a first action on the merits within 1 to 4 months. Now, the PTO, perhaps at the outset of its program, has limited the number of prioritized applications to 10,000 acceptances per fiscal year. And that fiscal year runs from October to September. And a request must be filed before the date of mailing of a first office action or after a request for continued examination or RCE is filed. Only one RCE Track 1 or prioritized examination request is allowed per application. Now, I'd like to review with those requirements in mind, if you're successful in submitting your prioritized examination request, what are some of the advantages and best practices that would be appropriate for you to integrate into your intellectual property strategies and plans. First, you can pursue a prioritized examination rather quickly to ascertain the patentability of an invention. And if it's patentable, then you can get granted claims very quickly. If it's unpatentable, then what you may be able to do is avoid the expense of foreign filings and related fees. If your invention is not a strong candidate for a patent, then you can also request non-publication of your application so it won't become available to the public, and then maintain your invention as a trade secret. Ultimately, again, that's if you're not successful in getting allowance of the claims during the prioritized examination period. Following a successful prioritized examination, you can then use the patent prosecution highway to get your claims granted in other countries where they are in agreement with the U.S. Patent and Trademark Office. So this is a quick way to get your claims granted in foreign cases by piggybacking off of a prioritized examination in the United States. Typically, a good practice to use is to apply for your patent with narrow claims that will cover your commercial products, get those allowed using prioritized examination, and then follow with continuation applications that seek broader protection and without having to pay the prioritized examination fees associated with those cases. For a previously submitted application, you can request prioritized examination for those continued applications, though, if you want. To facilitate effective prioritized examination, even though you don't have to conduct a pre-examination prior art search, it may be a good idea to do that to identify the closest prior art. If you do that, then you can fashion or craft your claims to avoid that closest prior art, thereby improving the likelihood that the first action you get from the Patent Office is an allowance. Afterwards, you can pursue your broader claims in a continuation application. Also, because of the 10,000 application limit, it's a good idea to file your petition earlier on in the fiscal year as opposed to later in the fiscal year. So applications where you want prioritized examination, you'll want to check the Patent Office to see if there's an update on the number of approvals to know if they're approaching that 10,000 limit. And if they're not, then you can proceed, or if they're getting close, you may want to delay seeking your prioritized examination until the beginning of the next fiscal year. By way of review, the Patent Office has some statistics available for how the program that describe how well the program's functioning, but they're only through the end of 2011. So for the first 3 months that prioritized examination's been available, we do know the following. About 1,200 petitions had been filed in 2011 with an approval rate, so those that qualified for prioritized examination, of just shy of 99%. So most applicants that were submitting their petitions for prioritized examination were following all the rules and completing the applications correctly. Almost 650 had received first office actions, which is indicative that the Patent Office really was turning around those applications very quickly. 23 had been allowed, and 3 had received final office actions. The petition pendency on average took about 41 days. So after the application was filed and a petition for prioritized examination was sought, the Patent Office alerted the applicant that they had qualified, typically within just over a month. And the USPTO reports that it has so far exceeded its goal of getting out first office actions within the 3 months. They also reported that after receiving responses from applicants, final office actions were typically issued in just over a month, or about 34 days. It'll be interesting to watch how in the coming months and the first few years of practice, how these statistics continue to bear out, and if the Patent Office can effectively use prioritized examination to quickly move patent applications through the process. I hope you found this presentation helpful. Thank you very much.